Good evening, everybody. Give me a second. Let me move this microphone around. Give me a second, y'all. That should be good because I really only want it on me. I don't want it on anything else. Sorry about that, y'all. Okay. Hopefully that is pretty good. Hopefully everybody can hear me. Had a long day today, y'all. Long day. Office desk is a mess. Let's see. I'm about to place the call-in number into the chat just to let everybody know. Let's see. All right, that's the. I just posted the call-in number into the chat, everybody. So. I have a call-in number tonight. You can call in. We can talk. We can talk about criminal cases of 42 Section 1983 lawsuits. Pretty much any type of lawsuit. It really doesn't matter, to be honest with you. If I know how to do it, I'll tell you. The call-in number is in the chat. If you want to make donations, because some people like to make donations, I really appreciate it. For the channel. The cash tag is there. That's the cash tag. And the PayPal, I'm about to post that right now. Let's see. All right, and that's the PayPal. So if you want to make donations or whatever, I don't care what it is. I'm not being picky. You donate whatever you can if you want to donate. Criminal cases, 42 Section 1983 lawsuits. I want to go back to, I'm going to have to pull it up on another window. What is this? Yeah, I'm going to pull it up on another window. Because I want to talk about, y'all know I've been posting a lot of case law. I always post a lot of case law on the community section of the channel. I do hope the case law is helping you understand what's really going on, in the system. And I hope y'all are actually going to read some of these cases, because all of these cases that I post on my channel in the community section, these are real cases. I know they're real cases because judges are citing these cases in support of their arguments in the cases that I read. Sometimes I read those cases. Sometimes I don't. If I feel like I need to read the case, I will. But if it's a principle, I'm not going to even read it because I pretty much understand principles in law. Not all of them, but some of them. Okay, let me go. I'm gonna go to the community section because I want to talk about something that I posted, and I think somebody commented on it, if I'm not mistaken. Let me see where it's at. Here it is, right here. Okay, somebody commented on this. Is a case from Minnesota. It was cited. I'm gonna read this to y'all. This is very important. I just want y'all to know this because it's always. It doesn't matter what you title the document. It matters what the substance of the document is. Like, what are you asking for in this document? What are you seeking? What remedy are you seeking? That's what matters. It doesn't matter what you call it. So I'm gonna read this to y'all, and I'm gonna read y'all my comment on it because I want y'all to understand this. It says the articles of incorporation are the charter of a corporation and subject to constitutions and laws of the state. its fundamental and organic law. Did y'all read that? The charter of the corporation, this is what that case is telling y'all. I don't know if y'all remember, but I probably a few weeks ago, I cited case law that basically said the charter of the corporation is the corporation's constitution. So this one right here is just saying the articles of incorporation are the charter of the corporation. In other words, it's telling you that the articles of incorporation are the constitution of that corporation. It doesn't have to be called constitution in order for it to be a constitution. Do y'all see what I'm saying? It doesn't matter what it's called. It matters, the substance matter. Let me rephrase that. It matters what the substance of the document is it's objective is what I'm trying to say. I'm trying to put this in a way to where y'all can understand it, because I don't want to confuse anybody. But anyway, in the bottom I say, in other words, articles of incorporation are that corporation's constitution. And again, I say it does not have to be titled a constitution for it to be a constitution. Now I want y'all to think about that. Think about when it says the Constitution for the United States. That basically, in my opinion, is a charter. It's a charter because we all know, and it's my contention. I'm not sure what anybody else think, because I don't want to, I don't want to mislead anybody or anything like that. I would rather you just do your own research. But it is my contention that the United States is a corporation. There's a corporation called the United States, and I can reasonably conclude that because I've read cases that are saying it. It has a DUNS number, and since it has a DUNS number, I'm going to reasonably assume that it has an EIN number. So since it's a corporation, that constitution is, in other words, it's an article of incorporation, is what I'm trying to say. It's a charter that they were delegated from Congress. So somebody delegated them that charter to exist, is what I'm trying to say. So this corporation, I want y'all to notice now that they call these officers of this corporation, these so-called citizens or whatever of this corporation, officers, or in other words, franchises of the federal government, or citizens of the federal government, federal citizens, or so on and so forth like that. I just want y'all to let y'all know that corporations are citizens. A corporation is considered a citizen, just to let y'all know. That's why when I go and read these cases, some of them, I just go straight to the case citation, and I copy and I paste it on into my the community section, because I want y'all to see this stuff. I already know this stuff because I've read so many cases, so I already know this stuff. But I just want y'all to understand, it is my contention that the United States is in fact a corporation. Its constitution is its charter, or in other words, its articles of incorporation. And that corporation has been, it has territories, and it's no different than any other corporation. Let's say a corporation, let's say this corporation buys land or whatever, and this land is this land is governed by that charter of that corporation, or in other words, those articles of incorporation of that corporation. Is this making sense to y'all? Let me know if I'm not making sense to y'all. So just give me a yes or a no if I'm making sense or not. I'm trying to dumb this down because I'm freestyling this stuff. I'm not looking at nothing. I'm freestyling this stuff. So I'm trying to dumb it down into a way where you can understand it. Let's see. If you haven't already, please go ahead and pound that like button and that subscribe button if you haven't already. I'm not sure how many viewers I have, but I should have at least some likes. So I would really appreciate that if y'all did that. there was some guy. Well, I had a consultation with somebody, and long story short, he wants me to litigate his case for him. His federal lawsuit for him. He wants me to litigate the case for him. It's one case that I've never done before, but I'm about 100% sure that I can do it. It's on a diversity jurisdiction. Just to let y'all know, y'all probably already know this, but you can sue in federal court. There are three subject matter jurisdictional statutes. In other words, to invoke the court's subject matter jurisdiction. Now, U.S. District Court subject matter jurisdiction. There's one, the federal question. The other one is under the diversity jurisdiction, and I think it's one more, but I can't really remember it. But anyway, so what do y'all want to talk about, man? Let me know. Y'all have any questions? Anything? What do y'all want to talk about? You can just list a topic. If it's relating to criminal law or civil law or something like that, if I know about it, we'll talk about it. If I don't, I'll let you know, and we can just talk about it. Also, the call-in number is 563-999-3602. Y'all can call in and press 1, and we can engage in a Q&A. I'm gonna see if I can read. Oh yeah, another thing I wanted to talk about. I'm on the community section on my channel right now. There was an excerpt from my ebook that I've been it's another ebook. I'm titling the ebook it's called Admiralty. That's the name of the ebook. But I posted I put a post up here, and it's telling you all of the bonds in Admiralty. And then I cite case law in Alabama, and I'm comparing these so-called statutory bonds to the bonds in Admiralty jurisdiction. And if you read these bonds, both of them, you'll see that the nature of the action is Admiralty. That's the nature of the action. It's Admiralty. Let me see. I don't like this new chat, Blue Sky. I don't know what that means. YouTube, was it new? YouTube must have got something new, so I really don't know what they're doing. Looks the same to me. They must have did something different. I'm not sure. But what do y'all want to talk about, man? You can call into the show if you have any questions. Like if you got a case right now, traffic ticket, certain felonies you're not gonna kind of talk about. And certain felonies I can't, because I don't want to give you the wrong information. Different, the states, they have their own different laws or something like that. So, but the principles are pretty much, they're always going to be the same. Do y'all remember when I was like, let me go back. Hold on. I want y'all to go, when y'all get some time, if y'all haven't already, go and read that excerpt that I copied and pasted from my ebook in here, where it says, in Admiralty courts, bonds are called securities or cautions, and are agreed upon between the parties in one of the following types of bonds. I cite all 4 of them. Okay, and then after that, I pull an Alabama case, and there's a statute right there. There's a statute in that case, and it says in Alabama there are 4 types of bail provided for in Title 15. What is it? Yeah, Title 15, Section 13, Section 111, Code Alabama 1975. And it goes on and so on and so forth. But there's some more of them too, by the way. But anyway, I promise y'all, if y'all go and read those bonds and compare the ingredients of each of those bonds, you are going to see that the nature of the action is Admiralty. A statutory bond is an Admiralty bond. They just calling it statutory because they don't want to say it's Admiralty. That's really it. They just don't want to say it. Let's see. Let's see. Yeah, I can. I've actually done divorce cases before. just to let y'all know. I did one for free when I was just curious to see if I could do it. And this was years ago, but I did it. Her divorce was granted. But it depends on which statute that you are bringing the divorce under, because different causes of actions. In other words, like a cause grounds for divorce is just similar to it's similar to a cause of action. Doesn't matter what you call it. So different causes of actions have different ingredients. Different food has different ingredients. A red velvet, I'm always use this analysis. A red velvet cake and a German chocolate cake have different ingredients. So let's say you want to get a divorce for adultery. Then of course you would know the elements of adultery would be, you had sex with somebody other than your spouse or something like that. But you would list the facts. Okay, you would tell a story and you would list these facts. Another one would be like, let's say if you abandon your spouse, then you wouldn't talk about adultery unless you're using the statute for adultery for your state. Abandonment, you would only talk about facts that prove your spouse has abandoned you, or so on and so forth like that. Is that making sense to you, Five? I believe you, Libra Justice. I believe you. Blue Sky, you correct. Statutes are not laws. It's policy. Let me tell y'all something. Somebody called into the show the last time, and he was like, the statutes are the bylaws of the corporation. I believe that of the corporation. I believe that they're the bylaws, I believe that. I don't remember his name, but when he said that, it kind of resonated with me. I started to think about it a lot more, because they are corporations. They all. I don't even see how that they are claiming 11th Amendment. Matter of fact, yes, I do. I see how they are claiming 11th Amendment immunity now, because they're saying, because the state constitution or whatever, which is their article of incorporation, or in other words, their charter. They're saying, it seems like they're saying that we are their employees of this corporation, and since we're an employee of this corporation, we've somehow, I guess, waived our right to sue them. I don't know, something like that. It seems like it's something like that, to be honest with y'all. But if it's not, then they corporations and they shouldn't have any immunity. I don't know any corporation in any state that has an immunity, because they're all citizens. They're corporate citizens. They snapped the mat. Okay, Libra, if you don't mind, can you call in and we can talk about it? And I'll see if I can help you. Call them. I'm gonna post a number again. You call in to the show. And you don't have to give your name or anything like that if you want to remain private or something like that. I post a number in the chat. Call in, press 1, and then we'll talk about it. I'll put you on there, and then we can talk about it. And I'll see if I can help you. But these I don't doubt anything that you're saying, because they just corrupt. Like, I don't doubt any of that. I don't doubt it. If you haven't already, y'all, please go ahead and pound that like button. I really appreciate it. Now that like button. Hit that like button for me. Let's see. A letter to visit them in March, since the judge prosecuting me from behind bench. Y'all can call into the show, 563-999-3602. Press 1, and then we can talk. Last time I didn't see the live, but there was wrong information put out there, and I was like, oh my God, I hope nobody followed that. He says, but both of y'all were talking about it, and I brought it up, and you just didn't correct him on it. But I think it was like your first or second time just to go live, and y'all were deep into the conversation. Well, I was going to ask you, did you know what we were talking about? Because if you did, then I I would I could talk about the subject, because like I said, I don't want to give the wrong information. Most of this stuff that I'm telling y'all is just my own personal beliefs based on my research and experience, just to let y'all know, because I do have litigation experience. I'm not gonna do that because that's private. But I still have all of the divorce complaints that I drafted for people here. But their stuff is private. Let's see. I don't know, Libra. If you knew, we could talk about it, but I don't really know. Again, y'all can call into the show 563-999-3602. If you haven't already, please go ahead and hit that like button for me also. Also, if y'all disagree with anything that I say on here, let me know. I don't mind being corrected if I'm wrong, because I'm not right all the time. So I don't mind that. Let me know. Just don't start trolling, because then I'm gonna just block your ass. I don't have time for that. Okay, we got a caller. Okay. Caller 7517. Good evening. How you doing?
Hey, not too bad. You hear me?
Yeah, I can hear you. What's good, man? How you doing?
Not too bad, my friend. This is Alex, and I had a question. I'm helping someone with a divorce. Is it basically like any other lawsuit? You prove these elements of the divorce, you have evidence?
That's exactly what it is. It's a lawsuit.
Action?
That's exactly what it is, because it's a lawsuit. It's a lawsuit. It ain't no different than a criminal case. A criminal case is a lawsuit. They suing you. It's the same thing. The same exact thing. So,
and when it comes to, like, let's say the house, the cars, there's children involved. Can you ask for the entire house? And then if you don't get the entire house, maybe then the judge will just give you half of it, for example. How's that work?
Whose name is on it? Did they get it together?
I think so. Yes, sir.
And if they got it together, they're gonna need to come up with some. Look, man, I strongly advise you to tell whoever it is that is getting a divorce that they gonna need to talk about that with their ex and come to some type of resolution, because you don't want them people splitting up your assets and your property. You don't want them doing that. How they want to do it, or something like
that. They get a piece of it?
No, what I'm saying is you don't want them coming in like, okay, well, we have two grown adults in here and they're fighting and they can't get along, so we're gonna solve this issue for them. We gonna decide who gets what, and so on and so forth, like that, based on the law or whatever. Since they've already invoked our jurisdiction, they gave us the authority to do this because somebody petitioned this court for a divorce. So they invoked our jurisdiction, and so since they can't figure this shit out on their own, we're gonna do it for them.
But the problem is, it's impossible speaking with this individual. It's impossible resolving anything, and the issue is they're trying to get a order of protection first, and then they're going to be working on that divorce. You see what I mean?
Yeah.
Does the divorce have to be filed in the state where the state that they left and where the house resides, where they used to be, or the state that they're now in and they want to live in now?
In my opinion, it's going to depend on what the statute says. I know here, you can file it. You have to be a resident for at least 6 months to file it here. If you move from another state to here, you have to be a resident for at least 6 months before you can file it here. So it may be similar to that, to that particular state.
So basically, since she or this individual, they would have to reside in this state apart from the marriage 6 months before she can file for a divorce, right? In the new state.
Well, here is six.
Like get residency, right?
Yeah, here is 6 months. I don't know what it is for the particular state, that she's in.
In South Carolina.
South Carolina. Let me see if I can look it up for you right quick. Give me a second. Let me get on Google right quick. South Carolina.
Mm-hmm.
Matter of fact, I probably can do it here. Marriage residency. Here it is, right here. Okay, let's see. But the marriage must be administered within the state. Okay. Mexican, South Carolina, the general age. It looks like, if I'm correct, and this is just something I quickly done. So I don't want, like I said, I don't want to give you the wrong information. But let me see which website this is. It looks like a South Carolina website. Let me see. County of Lexington, South Carolina. Marriage licenses, procedures, and requirements for obtaining a marriage license. Oh, now this is for a marriage license. We talking about a divorce. Okay. So this is the license, obtaining copies of the marriage license. Okay, we're gonna do the divorce. Divorce residency requirements. Let's see. In order to institute an action for divorce on bonds of matrimony, a plaintiff must have resided in the state at least 1 year prior to commencement of the action. Okay, well there you have it right there. So you got to be a resident for at least a year.
Wow, a year.
Do you want me to give you that code?
Okay.
That section?
Sure. That'd be awesome. If you throw it in the comments, I can copy and paste. Or, take a screenshot.
All right, I'm about to do it right now. It's gonna say. No problem. It's gonna say residence requirement. That's what it's gonna say. Matter of fact, I'm just gonna post the whole link in here. That's what I'm gonna do. And that should help. Let me.
Can you give any clarity on the order of protection? How that is done properly and stuff?
Yeah, I mean, all of this stuff. You overthinking this stuff, Alex, because all of this stuff works the same exact way. It's just a petition or a complaint. So you have to have facts in support of that petition.
Well, that's what I explained to her. Yeah, and then basically everything comes down to evidence.
Yeah, everything. It's all about the facts. All about the facts. The facts on the evidence.
That's why they gave her a trial, and now she has to work on getting her ducks in a row as far as evidence, and then presenting it at trial. Now, is it okay to get order of protection where she lives now, or does she also have to get one in the state that she left?
Let me see. I'm gonna see if I can do that for you right quick. Order of protection. I think she can, just to be honest with you, because it doesn't make sense for it to be a resident. Well, it kind of does make sense for us to be a residency requirement because of venue.
She's working on residency.
Okay, South Carolina. Let me see something. Give me 1 second. Order of protection. Time. The order of protection will be granted for a time period of 6 months up to 1 year. Requirements. Let me see if I can do the requirements. Release time, registered request. 24 hours. Let me see. I found something, but I don't think it's not really answering your question. Let's see. What is an emergency protection?
Now, quick question.
Go ahead.
Would South Carolina have jurisdiction to summons this guy out of state since now the residence is here?
Has she? Okay. So if she petitions the state where she is now for for divorce or for an order of protection, do you asking would South Carolina have jurisdiction? They probably wouldn't. I'm not really sure, but I don't think she can petition for a divorce.
Well, she can't do a divorce because she's gonna do residency here. But as far as she has to provide him the order of protection, and he has the right to face her accuser, she's in a different state. So, would he be forced to come here, or how would that work? Because she wants the order of protection in South Carolina, where she's going to be residing now. You know?
Yeah. I've never really dealt with anything like that. I'm trying to see what would be the just thing to do, because they're gonna do. I'm thinking that they're gonna do some type of equity. They're gonna try to make it as fair as possible.
Or would she have to file it in her home state where the house is, but live somewhere else to where her with the children have to go there, far away to that home state, to make it easier on the husband.
How long is she?
2 weeks.
I know she can't petition for a divorce there. Then she got to be there for a year.
Yeah.
Mm-hmm.
But she first needs this order of protection. That way, nothing bad happens.
I'm trying to. I don't know if there's a resident. Let me see if there's a residency requirement for that. Let me see.
Because she could do it in the home state where she's from, but it'd be hard on her, going back to the where the house is.
Order temporary possession of residence in South Carolina. I'll tell you what, let me see something. I'm gonna do this another way. Give me a second. I'm gonna see if I can find something like this. I'm not finding it right here. We're in South Carolina. Let's see. All right, let me see. Position of resident requirements, order of protection. Let's see. A person may see order of protection from injuries and also remember if we apply the provision using the first subsection. This was probably gonna take me some time to do. I want to say that it may be a residency requirement, or it may not be a residency requirement because of the seriousness of it. Because she's trying to get protection.
And since you have other callers, let me ask one final question. And that final question is, how can she protect herself if the individual claims she kidnapped the children?
Kidnapped the children. Let me see. I mean, if she's protecting her kids, then that would be, in my opinion, that would be an affirmative defense against against him saying that she kidnapped her own kids. How the hell you gonna kidnap your own kids? Boy, these people crazy, man. I'm trying to think.
She cover all her bases.
Yeah, I see what you're saying. I don't see her. I don't see it being. All right, let me ask you this: does she have any type of record back in the state where she just left, where she's filed complaints against him or reported him to the police or something like that? Because she can.
Police report.
Yeah.
There are police reports.
Yeah. Well, she can use that as a defense, for fleeing the state, with her kids. Generally, in my opinion, women are gonna do that anyway. Women are they're gonna always be overprotective of their kids. That's just how women are. So she could use all of that, as evidence in support of her supporting her affirmative defense of saying that, she was, she was protecting her kids, so she left because he was abusive and so on and so forth like that. I don't see that happening, to be honest with you. But they try anything, but I just don't see it happening.
Okay, and what kind of court would this be filed in? District court, divorced after a year?
Probably some type of family court. I'm not sure. Like it's different for every state, so I really don't know. I know if it was filed here, it would likely be filed. I'm not gonna know. I don't think it'll be filed in the juvenile court. It'll be filed in some type of family court or a circuit court. I don't think it'll be filed in no district court, but I could be wrong. It all just depends on what the statute says.
Awesome.
Now you can.
Okay, I thank you so much for your time. Thank you.
All right, you're welcome. Let me see. I'm gonna see if I
Have
can.
a good night.
All right. I'm gonna see if I can get you some more answers, Alex. Let me see. Order of protection. If you still watching, Alex, give me a second. I'm gonna see if I can do some more research, and I'm gonna see if I can copy and paste this into the group chat for you. And I'll tell you which court it is. Let's see. Yeah, it's gonna be in a family court, Alex. I got a copy to a link here of a petition for an order of protection that I just found. I'm gonna post it right here. All right, click if you're watching the video, Alex, click that link that says SC Courts that I just posted. It says forms in it. That's a petition. Give me a second, Libra. I gotta catch up on all these comments. Give me a second. Okay. Give me a second, Libra. Alex, click that link right there that says sccourts.org and forms. Click that right there. Click that, and it should pop up for you. Okay, let's see, looking for another phone to call. I would love to communicate, and I'm glad you are here to bounce it off. You're a good man, I can tell. Thank you, Libra. I appreciate that. Just got in. Are they trying to get temporary full custody? SG, if you know more about this than me, SG, then you can call in and just press 1, and they're listening to the show, so they can they can hear what you're saying. I'm not really sure. But I think Alex is still here, so he should be commenting. Okay, let me see. I'm going to post a link again for you, Alex. I'm going to post it twice just so you see it. All right, I posted the link twice for you, Alex. So click that link, and a form is going to pop up. It's going to be a form with the format of how a petition for an order of protection is supposed to look in South Carolina, and it's going to be in a family court. SG, you can call in, press 1, and I'll turn the microphone on, and we can just go from there. I asked because my baby mama had some stuff so she could file a petition for abuse. If she proved our daughter was in danger as a result, she would get temporary full custody. That was in PA since there was no custody agreement. However, whoever had our daughter could take her wherever without say from the other parent. Yeah, that's kind of how they do it here. She also filed for full custody that kept her from being allowed to move after which was her plan from the beginning. She had to wait till custody was declined. PA is a commonwealth, and all custody issues go through them. When the child is born, there are no matter where you move. Damn, not sure if that applies to this issue. I don't think that would. I don't know. Maybe I'm wrong because like we all know, like different states have their own so-called laws or whatever you want to call it. Yeah, I posted it in the live chat area, Alex. You should. If you don't see it, let me know and I'll try to put it somewhere else for you. But it's in the live chat. And if you can't see it in the chat, what I'll do is I'll go over to the community section of the page, and I'll post it in the community section, and you should be able to do it by click on it from there. Okay, Libra, let me get back to you right quick. Maybe you may be dialing the wrong number, Libra. I'm not sure. I'm gonna post the number for you again, Libra. I just posted it again. That's the number. Just call in and press 1. I gotta get up early in the morning, y'all. I gotta go to the barber shop. Gotta make some business moves tomorrow. Do you see the link, Alex? Damn. Nothing working, Libra? Well, I don't know. Like I just had somebody call in, so I'm not sure why why the number is not working for you. But I just had somebody call in, and we just got off the phone. It was me and Alex, come to think of it. Y'all hit that like button. Hit that like button for me, y'all. I really appreciate it. Thank you. Not a tone. A ring, not a damn. I'm sorry, Libra. I don't know what to do. I'm using Blog Talk Radio, so I really don't know what's the issue with that. I don't know, Libra. Let's see. All right, have any of y'all filed any lawsuits yet? Let me see. Yes, after exiting and coming back, and I do see the 2 links. Thank you. You're welcome, Alex. Protection from abuse. She might be able to get that protection from abuse, Alex. I'm gonna read over this form and see what it says, Alex. Let me see the personal county. I don't really see it in here. There's an act. I'm gonna go and read this act since I don't have any. Somebody just called. Give me a second. All right. Caller 2664. You're on the line. How you doing?
Good. How you doing?
I'm good. What's good?
I was just I came in a little late, so I missed the last caller's story. I have my own experiences with protective orders and custody stuff, so I wasn't sure if I could add to whatever their issue was. What was this somebody whose wife was going through something with their ex?
I think so. I think there was a woman, she was being abused, so she fled the state, took her kids, and she went to another state. And now she's trying to petition for an order of protection from abuse in the state that she ran to. And she's trying to get a divorce there too. She can't get a divorce there because she hasn't been there for a year. I think she can get a protection from abuse. Matter of fact, she can, Alex, I don't know why, I forgot to tell you this, Alex, but she can petition for a protection for an order of abuse from the state that she just left from. She don't even have to be there to do that. Just to let you know, she can do that shit in the mail. Just to let you know, Alex. But is this SG?
Yeah.
Okay.
Yeah. So in my experience, my daughter's mom I'm pretty sure she already had stuff planned out, and she got something started and then basically lied on me to the cops.
Mm-hmm.
And we both filed PSAs against each other. And because she couldn't prove that whatever we went through at the time put our daughter in danger, they didn't do anything custody wise as far as I wouldn't be able to see my daughter. We just had to stay away from each other.
Mm-hmm.
So if she's trying to protect their child, she needs to make sure that if there's something where the child was also in danger, she needs to explain that, because at least with my situation, we had to stay away from each other, but I could still go, we could meet somewhere neutral and
Mm-hmm.
I can see my daughter.
Mm-hmm. She could, if she was being abused in front of the kids, they would, in my opinion, they would still consider that child abuse, because you can cause kids trauma, with them seeing stuff like that. So, I mean, she would have grounds there, if you ask me. But it would depend on. It just depends on.
But the other.
Go ahead.
The other thing I added in there was that, for some kind of way in Pennsylvania, when you're born there, you got to work your custody issues out in Pennsylvania. It can't be done in some other state. I guess because the whole thing with states being independent countries in a sense.
Mm-hmm.
That's how Pennsylvania is as far as when you're born there. You're always a Pennsylvania citizen. So I don't know if that affects whatever state that child was born in, but it's something that to keep in mind.
I really don't know. I didn't really ask where that she, which state she left. I just know she ran, to South Carolina. So that's where she may or may not be right now. But I really don't know, because like we just said, it just depends, because different so-called states have their own different so-called laws and so on and so forth. So it's not, once you figure out, where she is and where she just left from, then you could get an answer if you just do the research. But if she doesn't know how to do the research, or they don't know how to do the research, then they're not gonna know what to do. But it's not hard though.
And I'll also add that, if there is any kind of agreement, she better make sure she reads every word of it before she signs it. Because this was a long time ago, so I didn't know about all the legal stuff, but I still read everything.
Mm-hmm.
And my daughter's mom was in such a hurry to move, she didn't read what she was agreeing to. And that's coming back to bite her in the behind now. Because, I made sure that I had 50-50 custody before she left the state. Because my plan was, if I move to wherever they move, so I'm close to my daughter,
Mm-hmm.
I don't want any issues in the future. And that's how it worked out. We live in the same area, so our custody agreement's already straightened out. I don't have any issues with that. I'm just dealing with child support.
Yeah.
And that was also based on lies. But that's how it is when people get emotional sometimes.
Well, she can't. I mean,
so that's all I had to add. I know somebody else was trying to call in, so I didn't want to hold them up.
Okay. Well, I appreciate it, man. Appreciate it.
No problem.
All right. Peace. See, number of drops. Libra, I don't know, Libra. Like, no, that was you. That was another line ringing. That's not my cell phone number that I have on the screen. That's something else. Alex, let me see something. I think Alex said he got that link. Okay, yeah, you got the links. What else did you need, Alex? I might have a little bit more time. What else did you need? Let me go and read something on this app right here. Because I'm just not. What is it? Domestic Violence Reform Act. That's what they call it. Domestic Violence Reform Act, South Carolina. Let me go here. I'm gonna read something here. What is this? This is a long ass act. Let's see. All right, y'all call in to the show. Let me put the number back in the chat. I posted the number back in the chat. Let's see. I'm reading the Domestic Violence Reform Act right now for South Carolina right now, Alex. I'm reading the entire act. I'm not going to read the whole thing, but I'm trying to see if there is a residency requirement. I don't. It kind of makes sense to me that it is a residency requirement. Then it kind of makes sense to me that it isn't, because she's in danger. She may be in danger. Let's see. Let me see something. Is that it? No. Let me go here. Okay, now it's called the Protection from Domestic Abuse Act. That's the name of the act. So I'm reading the wrong act. Okay. I thought I was reading the damn wrong thing. So protection. Here we go. Right here, 20. Let's see. Harm means physical bodily harm, assault, or threat of physical injury. Okay, Alex, I'm gonna read you something since I'm already here. If she's listening or if she's around you, Alex, I'm gonna read you the definition for abuse in the Protection from Domestic Abuse Act in South Carolina. So in section 20-4-20 definitions, it says, as used in this chapter, abuse means 1, physical harm, bodily injury, assault, or the threat of physical harm. So he doesn't even have to do anything to her. That's still considered abuse. They got sexual criminal offenses as otherwise defined by statute, committed against a family or household member by a family or household member. Let's see. Okay, court means the family court. Petitioner means alleged abuse of respondent. In order for protection means, okay, let's see. Jurisdiction. Okay, the family court has jurisdiction over all proceedings under this chapter, except that during non-business hours or at other times when the court is not in session. The petition may be filed with a magistrate. The magistrate may issue an order of protection granting only the relief provided by section 2460A1, except as provided. Let me see. Let me see. I don't think there's a jurisdictional residency requirement. That's what I'm looking for. Because if she can just, if she can file it in South Carolina, then why not just file it there since she's there? except as otherwise provided, actions for an order must be filed in the county in which the act of abuse occurred. The petitioner resides or is sheltered unless the petitioner is a non-resident of the state. Hold on. Oh, okay, we're getting somewhere now, Alex. Okay. Matter of fact, I'm gonna post this section for you right now, Alex, and I'm gonna let you read it. Protection from abuse, non-resident of the state. Better yet, give me a second. I'm gonna see if I can find some cases on it. Neither the department nor its contractors may delay nor deny the placement of a child for adoption by a non-resident if that non-resident has been approved for adoption by the child of another state. Let me see. She willfully violated Jane Doe filed an action in family court seeking an order of protection from a threat of domestic abuse. Blah blah blah. Also, Alex, she doesn't have to have her name on that order of protection from abuse. She doesn't have to have her name on it. Her husband, her ex, or whatever, he may try to make a big deal out of it or something like that. He'll probably know it's her anyway. But just for her privacy. Okay, she's watching now too. Good. Okay, let me see. Okay, SG. You filed the lawsuit already, right, SG? Libra S. Let me see. As soon as initial appearance is made, you can start asking for this discovery. Meanwhile, don't forget to ask for freedom of information. Okay, just what is the name of the act? Have them Google or go over. Okay, let me see. I missed the original question and have made many law books. Family law. What was the question? All right, Libra Justice. Alex wanted to know if this woman who fled one state to another because she was being abused and she took her kids with her, he wants to know if she can petition the court in which the state that she ran to for an order of protection for abuse. I believe she can, to be honest with you. You got to read your ebook first. Okay, discovery starts if you once you file your complaint, SG, they're going to determine right then and there, based on the allegations that you have in that complaint, if those officers are entitled to qualified immunity or any form of immunity. The reason they're going to do that is because if they are, then you ain't going to get no discovery. They just going to dismiss the case because they're entitled to immunity as a matter of law. But if you plead facts that show those police officers or some type of public servant violated clearly established law of which a reasonable officer would have known about, and so on and so forth, then they are not going to get immunity. They're going to answer that complaint. And after they answer the complaint, y'all going to have to go through some type of, I think it's a Rule 26F scheduling. You have to go and meet with their attorney. And then once you go and meet with their attorney, you're going to discuss basically how the case is going to be handled. After y'all have that conference, then either you or the attorney is going to file, I think a schedule agreement or something. I forgot what they called it. And based on what y'all agreed on, that will be how the trial is going to be handled. Like for example, it may say you get 2 sets of interrogatories, 2 sets of requests for admissions, 30 each. You can't go outside of that agreement. If you do, then the court will strike. The court is going to strike it because you're violating the agreement, or so on and so forth. After that, let's say in that agreement with you and defense counsel, they may say something. The agreement may say something like discovery shall be commenced as soon as the court files an order in regards to this scheduling agreement. I'm trying to figure out a way to say this so I'm not confusing y'all, because I don't want to use their language. Sometimes it just confuses people. Let me see. What was that? In my case, it was like this, Alex. Not Alex, but SG. After I met with their attorney and we discussed how the case is gonna, how it's gonna go, how many days we were gonna go to trial, and so on and so forth, like that. After I met with him, that's when we started discovery. Like after I met with him, he served his discovery on me right then and there, just like that. It was instantaneously, just like that. Any type of facts that you don't know that you want to know, you can get almost all of it through discovery if it is relevant to the case. You may not be able to use all of it because just because it's relevant doesn't mean it's admissible. I'm using Blog Talk Radio, Libra Justice. Okay, Alex, I'm going to get back to you right now. Let me go and read this statute. I want you to read this statute too, Alex. It says it is a section 20. I'm going to give you this section, Alex. I'm going to copy and paste this section for you right now. And I'm going to post it into the chat. All right, Alex, if you're watching, copy and paste that into Google. And, type in South Carolina or something like that and read that statute. The section that I'm reading is it is section B 2 through 4 in that section. And I'm gonna read it again. It says, except as provided in subsection C, actions for an order of protection must be filed in the county in which the alleged act of abuse occurred. Okay. The petitioner resides in or is sheltered unless the petitioner is a non-resident of the state. So you probably can file it anywhere since she's a non-resident of the state. You probably can file it in any family court in any county since she's not a resident of the state. Let me go on and read it some more. The respondent resides unless the respondent is a non-resident of the state. Okay, I would say yeah. I would say that she can file that petition in the county in which she's in right now because she's a non-resident. But I'm about 99% sure on that. So give me a second. Let me see if it's gonna tell me to where I'm 100% sure. This is all the parties last resided together. Let me see. C, if the action is filed in the county in which the petitioner resides or is sheltered, and the respondent is a non-resident of that county, the petitioner must request that the action be immediately transferred to another county in which venue is proper and must include a supplemental petition that designates the transfer county and that changes all specific references to the county of filing to the transfer county. The clerk of court must transfer and forward the supplemental petition to the transfer county. Okay, if the petitioner is a non-resident of the state, the action must be filed in the county specified in item 1, 3, or 4 of subsection B. Okay. Are you getting that, Alex? I think I'm gonna post it again. Scroll down, Alex, to section 20-430 in that code section and go down to go down to C2. And it says that if the petitioner is a non-resident of the state, the action must be filed in the county specified in 1, 3, or 4 of subsection B. Let's see, let me get back to the comments. Let's see. This is regarding my contested child support case. I sent their questionnaires back and haven't received anything from them. Just making sure I don't need to be doing something. Thanks for the info. Oh, you were talking about child support. See, I was talking about a federal lawsuit. But I mean, you should have discovery in child support and all that, because if you get discovery in a criminal case, I don't see why you wouldn't get it in a civil case. Because I got discovery in a civil case. It was a federal case. Are you reading that section, Alex? Was it section 2430? So where let me see. So where she will now reside, right? Let me go back and read it again. Let me see. If the petition is a non-resident of the state, the action must be filed in the county specified in item 1, 3, or 4. 3, the respondent resides, unless the respondent is a resident of the state. Let me see. Of section B, okay. In which this is why I don't like reading statutes. They kind of sometimes they're pretty clear sometimes, and sometimes they're not. It would make sense to me, Alex, for her to file that petition because she's a non-resident of that state. So it would make sense, in my opinion, for her to file that petition in the county in which she is in now. I'm gonna go in and just do some more research just to be sure. Let me see if I got any questions. Now I don't have anybody raising their hand right now. Y'all can call into the show if y'all want, just to let y'all know. Let's see. Let's see. If the petitioner is a non-resident of the state, the action must be filed in the county specified in item 1. See, the alleged act of abuse occurred. No, it didn't occur. There are 3. The respondent resides. Or 4. The parties last resided together. Unless the respondent is a non-resident of the state. I got a better idea. I need something clear, because I don't want you to be running around. You're doing the wrong thing. So I need something clear. Non-resident petition for order of protection from a person may seek an order of protection. Let's see. Let's see. Non-resident protection for Let's see, personal. You're welcome, Alex, by the way. I'm doing some research on it right now, just to let y'all know. If y'all have any questions, go ahead or call into the show. Let's see. Let's see. Indeed, the only rights a non-resident can have regarding I'm spending too much time on this. Let me go. I'm spending too much time on this, so I don't want to spend too much on it. Did you get that statute though, Alex? Oh, you said yeah. I will look it. Okay. All right. So you got the statute. I'm gonna read this one more time. It seems to me that she can. That's just what it seems like to me. Let's see. If the petitioner is a non-resident of the state, the action must be filed in the county specified in item. In the county, okay. It's not saying anything. Okay. The petitioner resides or is sheltered unless the petitioner is a non-resident of the state. I don't know. I think this would probably come down to that minimum contact type thing. She's a non-resident of the state, so she might not be able to file it there, Alex. But I'm not really sure. She may not be able to. When thinking about minimum contacts, she may not be able to file it. But again, I'm not really sure. Because it says if the petitioner is a non-resident of the state, the action must be filed in the county specified in item 1, 3, or 4. Okay, the alleged act of abuse occurred. Okay, so she wasn't abused in South Carolina. So let's go to 3. We're gonna rule that out. The respondent resides. The respondent doesn't reside in South Carolina. And 4, the parties last reside together. I don't think any of these statutes. I don't think any of them are applicable now that I'm reading them closely. Unless the respondent is a non-resident of the state. Unless, let me see. Maybe I need to look up what the word unless means, even though I already know what it means, but you got their own meanings to this shit. Okay. You're welcome, Alex. But if she can't do it in South Carolina, tell her to just do it in the state that she just left from. Matter of fact, if you don't mind, which state did she just left from? And we'll just kill all of that right now. And I'll just go ahead and look up a form, for that particular state so she can petition her home state for that order. If you don't mind, Alex. We can just do it like that. Also, like if I was her, I would probably use maybe a PO box or something like that. If she didn't want him to know or whatever, it really doesn't matter. Okay, if y'all haven't already, go ahead and hit that like button for me. I appreciate it. I'm getting hungry, y'all. As soon as I get off here, I need to probably order me something to eat right now. Tennessee. Okay. All right, give me a second, Alex. Let's see. All right. Let's see. All right, let me see if this is it. All right. I found it, Alex. Okay. I'm gonna post it right now for you, Alex, and we'll just do it like that. All right, I just posted it into the chat. Alex, let me know if you got it. If you didn't get it, let me know, and I'll post it again. Okay, good. Okay, this one's about 6 pages long. Okay, yeah. Yeah, this one's about 6 pages long. But it's pretty straightforward though. I don't think this one is hard at all, come to think of it. Just read the form. Order of dismissal, affidavit file, bail order, form in abuse cases, order of protection, exploitation, order of protection, petition for lifetime, order of protection. They have another one on here. It says a petition for lifetime order of protection. Not sure if you would want that. I'm gonna post a link to where all the forms are on this website. There's another one. That's a link to where all of the forms are, Alex, for Tennessee. I'm not gonna say all of them, but there seems to be a few forms on there. So that's why I'm posting that link for you. All right, I have about 40 more minutes left in the show. If y'all want to call in, or if you have 42 Section 1983 questions, criminal cases, whatever, doesn't matter. I'll post the number again. I think I need to say something, so I'm gonna go ahead and say it. It doesn't matter what type of action it is, y'all. Some of y'all y'all seem to be overthinking this. It doesn't matter what the action is. Everything in court generally is going to start with either a petition, which is nothing more than a complaint. It doesn't matter what you call it. It's gonna be based on the facts of the case. It's always the facts, y'all. Well, I got about 5% left on my phone. How the hell did that happen? I have to cut this live short, y'all. I got about 5% left on my cell phone. So we'll have to end this one kind of early. Probably about 10 minutes, maybe. Got a question. What's up, man? I pray all is well. What's your opinion when case law state that judges, state city employees are persons and aren't subject to 1983? Let's see. When case law state that judges, state city employees aren't, well, that will be inaccurate because judges have been sued pursuant to 42 section 1983. Let's see, you said state city employees. You talking about state employees and city employees? Is that what you mean? If that's what you mean, then they are not, if they're not a public servant, you can't sue them under 42 section 1983. You just can't do that. I'm kind of dealing with something like that in the case that I'm litigating for a guy right now under the diversity statute. I think he sued some people that were employees of the town, but they weren't judges. They're not prosecutors. They're not police officers. And I'm kind of like iffy if he can sue them, and I'm gonna do some more research on it just to be sure. But they're public employees, so you should be able to sue them. I can reasonably conclude that based on that, that they're public employees, that you should be able to sue them. But I like to be sure. So that's why I read cases. But to answer your question, if you're asking if they're state and city employees, not officers, then I'm gonna say no, you can't sue them. Because judges are officers, police officers. You know what I'm saying? Prosecutors are officers of the court and so on and so forth like that. So I'm gonna say no if they're not officers. I don't know how I let my phone get down to 5%. Yeah, I don't know how I let that happen. I'm sorry, y'all. I'm gonna probably be live for probably about 5 more minutes, and that'll be it. If the phone shuts off though, then y'all know why. But it's on 5%. I wake up early in the morning. I gotta go to the barber shop. I'm tired. Let's see. Timothy. You filed your lawsuit already, right, Tim? I think you already filed yours. I think you sent me something in my email. I read it a couple of days ago. I think it was you saying that it's admiralty jurisdiction or something like that. You right. It's admiralty. They merged all these rules together when they merged the courts. They consolidated all the rules into like 2 sets of rules as far as criminal actions and civil actions. So the criminal aspect, let me rephrase that, the quasi-criminal aspect of admiralty jurisdiction is incorporated into in my opinion, it's incorporated into the rules of criminal procedure. No, I filed writs and motions to vacate orders. Okay. All right. If you believe that you are entitled to have that order vacated and they don't want to do it, you probably gonna either have to appeal it or you're gonna have to petition for a writ of mandamus to a higher court to get that lower court to do their damn job. And they just get on my nerve. One thing about these people though, they gonna teach your ass law. When they violate your rights and they piss you off and you go to the law library and you start studying, they gonna piss you off a lot. I'm telling you that now. But they gonna teach you law. Man, they gonna teach you that. They taught me a lot. Every time they pissed me off, I went to the law library. Every time they pissed me off, I just went to the law library. And I just started studying. What's good, JR? Let me see what I got. My phone going dead, y'all. Let's see. I got 4% left. Yeah, JR, I do. I have a call in tonight. But my phone going dead, man. I don't know how the hell I let that happen, y'all. It's on 4%. It's probably about to hang up. I don't know how the hell I did that, man. I wonder, can I charge it up? Let me see if I can charge it up while we live, y'all. Give me a second. Probably. I might be able to do some. Let's see. I'm gonna try something out, y'all. Give me a second. 1 minute. Hold on. I don't know how the hell I let that happen, y'all. But it happened. I don't think I'm gonna be able to get it, y'all. I'm probably not gonna be able to get it. Damn it. I'm probably not gonna be able to do it. Y'all give me a second. I'm gonna try this out. Hold on, y'all. Let me try something out. All right, we'll see if this is gonna work. It's probably not gonna work. Probably. Let's see if that works. All right, I'm trying to see. Well, I mean, it's charging, but I don't know if it's gonna stay charged, y'all. We're gonna try it out. If it just cuts off on y'all know what it is. So we'll try it out. All right, we'll try it out, y'all. It's on the charger, but it's barely on the charge. It's on 3% now. So we'll try it out and we'll see how it works. Call in, JR. We're gonna try it out, man. If it hangs up, it just hang up. Let me see if I can get that number for you. I put it on the charger. It's charging, but it's on like 3%, but it's on the charger right now while we're going live. I don't know how the hell I did that. Running errands all day. I've been so busy, y'all. I put the number in the chat, y'all. You call in. We got about 30 more minutes. So we're going to try it out. So just go ahead and call in, JR. Yeah, you're going to learn, Tim. You're going to learn. It's not hard, though. You'll see everything is pretty much the same. Everything starts with either a petition or complaint, or it's really just a petition or a complaint. I mean, that's pretty much what it is. Or, all civil cases, they start with either a complaint or a petition. All criminal cases, sometimes they either start with a complaint. I know here they start with a complaint or an indictment. Here, it just varies, place by place, jurisdiction. Let's see. Got about 30 minutes. We're good. Y'all can call in if y'all want, man. Just call in. And we're Don't try that. Just press one and I'll turn your microphone on and we can just go from there. Oh boy. Let's see. Caller 5416. Good evening. How you doing?
Hey, what's going on? This is the government. How you doing?
What's good, man? How you doing?
Man, I just calling, man, because I know I talked to you before about my complaint, but not, and they filed a motion. They trying to file a motion to dismiss. They haven't answered the complaint. They filed a motion to dismiss for failure to state claim upon which relief can be granted. They filed for about immunity yesterday. So I thought it was just kind of shotgun, so they can't answer the complaint.
Okay, you said they filed. Who filed the motion to dismiss?
So the attorney that's representing the police officers filed a motion to dismiss for failure to state a claim. They didn't answer nothing they could think. They just went sort of through my causes of action and tried to say they were, just tried to say they were insufficient.
Yeah, they were legally insufficient as a matter of law, stuff like that. Yeah, that's basically what they were saying.
Right. Right.
Okay. I don't think.
I'm thinking that they can't answer the complaint because, I didn't provide none of my exhibits yet. I was waiting until they answered it and then provide exhibits and whatnot. Because I'm using their information. Their information will be used against them.
Okay.
I didn't arrest myself for no reason.
I would need to see your complaint, to be honest with you. I can't really tell you if they bullshit you or not, because I don't see I don't have a copy of the complaint.
Right.
Let me see. We got about.
So
we can
do a one-on-one, man. I don't wanna...
Go ahead.
We can always do a one-on-one one of these days.
Okay. Well, when did you get that motion to dismiss? What day did you get that? Because you got to reply to it. You got to draft a response in opposition to it.
Right. Got it on the 21st. A day ago. What's the 20? So they just mailed it. I went on Pacer and saw it.
Yeah. Okay.
But I haven't received it. I just went and grabbed it off the Pacer.
Yeah. Okay, that's normally what I would do anyway.
Yeah.
Well, you have. I think you got about 3 weeks to maybe 30 days to answer that. To file. Well, the judge. What's gonna happen is the judge is gonna issue an order, setting a deadline for you to respond to it. That's what's gonna happen.
Okay. Right. But you know what's so crazy? For them to state they can't state, they don't know any of the facts because they haven't answered the complaint. There are no facts until you respond, right?
Yeah, well, this is the standard for a motion to dismiss. Anytime they file a motion to dismiss, the courts are required, pursuant to the standard, to accept the allegations in your complaint as true, and they're going to determine, based on the allegations in your complaint, if these allegations are sufficient in law or not to justify your causes of actions. So, in other words, the attorney for the police officers, he is not disputing any of your facts. He's not arguing that they didn't do this or they didn't do that. He basically what he did was he got your complaint, he looked at it, and he says, this is legally insufficient as a matter of law, so I'm not going to dispute these facts because there's no claim here. There's no valid cause of action here, so I'm not even going to dispute it. In other words, by answering this complaint, and claiming all of these affirmative defenses and so on and so forth like that. That's basically what he did.
Okay. And would they do that? Would they do that because they know that maybe if they did answer that, they would be put in a position where, okay, a lot of these are true, you know.
I'm gonna tell you this. I'm gonna tell you that.
Motion for summary. He can motion for summary. You know what I'm saying?
Yeah, he did he claim qualified immunity at all? Any type of immunity?
No, I think claim qualified. No qualified immunity.
Okay, so he basically saying that the complaint doesn't have merit. In other words, he doesn't even have to claim immunity because the complaint doesn't have merit. I would need to see the paperwork, to be honest with you. Just to be honest with you.
Right.
Because I've never had that happen to me before. I'm gonna say this. If that complaint, and I'm not saying your complaint is bad, but if it was good, he would have answered that complaint. Because that you can't, if your complaint has merit, he is not gonna file a motion to dismiss because he's going to lose. And then when he loses, you can file a motion for judgment on the pleadings because you stated valid causes of action and he hasn't denied any of these allegations against him.
Right, that's what I'm saying. How can you even file? You have to write a terrible ass complaint for him to even say, hey, you know, based on this, you know what I'm saying? Like, it doesn't even make sense for him to even file a motion to dismiss because, like what you just said, I mean,
it makes. All right, I want you to think of it like this. We're going to use a criminal case for an example because it works the same way in a criminal case. So let's say you get pulled over by the police, whatever. They write you, let's say they take you to jail for disorderly conduct or something like this. You bond out of jail, blah, blah, blah. You get the paperwork and you just see disorderly conduct. It just says defendant John Doe was making unreasonable noise or something like that, blah, blah, blah. So you look at this shit and you say, this is legally insufficient as a matter of law because there are no facts in here to support his conclusion on how I was making unreasonable noise. So I wouldn't even answer that motherfucker either. I would just file a motion to dismiss, and I would say this complaint is devoid of the prerequisite elements of the offense. It's conclusory, it's vague, and so on and so forth, shit like that. You know what I'm saying? That's basically what he did. He looked at your complaint,
right,
and he I'm guessing he assumed that the allegations in your complaint were insufficient to justify the causes of actions you had against his clients, if that makes sense to you. That's what it sounds like to me. But again, I don't have the paperwork.
Yeah.
I don't know, because I can tell you if he bullshit you based on the allegations in the complaint. I can tell you that. But
yeah, because me and you had did a one-on-one. We did a one-on-one probably about a month ago. Me and you sat down and we went through the complaint a little bit. And I had some facts. I had all facts in there. Statements of facts. I mean, I didn't come to no conclusions, anything like that.
Mm-hmm.
And then at the end, I had my, my damages. And then after that, I had my causes of action.
Okay.
Fourth Amendment violation. Unlawful arrest, false imprisonment, excessive force. You know what I'm saying? So I think he just bullshitting.
It's possible. It's possible, but I would
send you the complaint. That's not a problem.
Let me see what time. Let me see how much.
But I didn't know I want to do it on your time. Here.
I'm free right now. You got about 20 minutes. You can send it, and I'll look at it. You got about 20 minutes. Let me see what my phone on. I hope it don't go dead. It is on. It's on 6% right now, so I'm guessing it's charging. So
yeah, sounds like it's charging. I'm gonna send it to you right now. Hold on 1 second.
All right.
Okay, where's my? Oh, it's okay. It's Suplo, right? TV.
Yeah,
Gmail.
smartlovetv@gmail.com.
I'm emailing it to you right now.
All right.
And then I was gonna ask you, how can you amend it? How many times can you amend a complaint? Do you know?
As many times as the court will allow you to, but you have to either you have to talk to them, you have to talk to their attorney, or you have to get leave of court to do it. So you can file a motion for leave of court. The easiest way is to talk to them and see if, hey man, look, I want to amend my complaint. Is that okay? Y'all have any
But
problem with it?
they probably don't want to let me amend my shit.
Yeah, well, that's why you got to file a motion for leave of court to amend the complaint. I did that for somebody a couple days ago. I need to do that. I was supposed to do that video trying to teach y'all how to draft a motion. I didn't even do the video. Let me go on. Did you send the email?
Yeah, that's what I was gonna ask you. You don't have you don't have a video on like a summary judgment or nothing like that.
I know how to do it though. All of it is easy, man. All of it is easy. Whenever I get that video up and just give y'all a breakdown of it, you'll see how simple it is. All you're doing is just saying comes now pursuant to rule, blah, 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 to motion this court for leave of court. In support of this motion, plaintiff states the following grounds. You state your grounds, and that's it. That's all you do. That's all you do, bro. I swear that is all you do.
Yeah, because I seen a guy amend his like time.
Yeah.
Damn.
When you pro se,
amend this shit a lot.
Yeah, when you pro se, they give you a little wiggle room when you pro se. Give you a little wiggle room.
So go to line number. Did you get it?
Yeah, I'm about to look at it right now.
I was gonna say start at line number 34.
34.
Because that's where my facts started at. So if you go down to page 9 is number 34.
All right, 34. Introduction. Let's see. Okay, plaintiff. Okay. Constant and in connection with the acts.
I don't know.
Laid in the complaint, defendants directly and indirectly use the judicial powers of the court's process to arrest, detain, and confine plaintiff against his objections. Venue is proper in the United States District Court for these this, blah, 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 B and C, because the defendant resides in the district and the events giving rise to the claims that occur within the jurisdiction. Okay. The events giving rise to the claims occur within the mountains of Wisconsin. You ain't really have some of this stuff you don't even need it in the complaint. Jury trial, minute, parties.
But smart look, I got a question for you.
Go ahead.
Even though some of the stuff is not needed in the complaint, they just have to deny it. You know what I'm saying? They still have to answer it if it's irrelevant to say irrelevant.
No,
you know
they don't. Like if they don't have to, if it's the reason why they're not answering it, is because it's frivolous. So that they're not going to even talk about it. The judge, I guarantee you, the judge is going to tell you everything that you did wrong in this complaint. They gonna do that. I'm looking at some of the stuff, and I can tell you what you did wrong. Because I don't think it should have been this long. This is 32 pages. I don't think it should have been this long. Let me see.
Okay.
Plaintiff was transferred to an office.
Another thing though, I am pro se.
Gotcha.
So they supposed to construe the complaint if I'm pro se, not guarding, not up to like technicalities and whatnot. So if there's something in don't need to be in there, as long as I speak a plausible claim,
You're right.
they're not supposed to say, "Oh, this is his defense."
Yeah,
You
you're
know
right.
what I'm saying?
You're right. I know what you mean. You're right.
So so that's what I was talking about. So I mean, but if you look at my statements of fact, all my statements of fact are on point. So for them to say, "Hey, motion to dismiss," that shit don't even make sense to me.
I like right here. You says number 39 and 40. You say what's it?
39 and 40.
Yeah, lacrosse's actions violated plaintiff 4th, 5th, 6th, 7th, 8th, and 4. Like you don't even have an 8th Amendment claim because you're not in prison. 6th Amendment, like you have to be very detailed with these facts. Some of these stuff, some of them seem like they're well, I ain't gonna say they're conclusions because it just seems like they're not put in the right place. But some of them you don't need. Plaintiff contacted the line for since the plaintiff was transferred to the hospital side. Plaintiff then stated that he needed help with retrieving his child from the other parent. The cause line located 4 p.m. Plaintiff anticipated the cause with aid and help in retrieving child. And cause did not assist plaintiff with aid or help with retrieving child. Like when you said plaintiff anticipated, lacrosse and Marseilles would aid and help plaintiff in retrieving his child, and they didn't like no offense, but who cares if they helped you or not? It's not relevant to your case. It's not relevant to a 4th Amendment violation. It's not relevant to a 5th Amendment, 6th Amendment, 7th Amendment, 8th. Do you see what I'm saying?
Right.
So don't even talk about it. Don't even. It's just irrelevant. Don't even talk. But this is how you gonna learn. So don't feel bad. This is how you gonna learn.
Right.
Let's see. Plaintiff was transferred to the cross.
So you saying that setup right there is irrelevant?
Yes.
That setup would be for like a jury to see, like, oh shit.
Maybe it would depend on what type of case it is, and this is not that case. I'm telling you right now, this is not that case. So it's irrelevant. Let me see. Lacrosse arrived at your address where plaintiff was located. Problem 4B. Okay, plaintiff anticipated Lacrosse would. Okay, let me scroll down some. Plaintiff anticipated spending quality time with his child and family. Okay, that would I can see that kind of being relevant because they deprived you of your liberty. Once they unlawfully detained you and took you to jail. You could just say that as a result, that hurt your feelings. You traumatized. I don't know, just something like that. You just got to make it make sense and make it believable believable to a jury. If it's reasonable and believable, and if a jury would believe it, then shit, you good to go. Okay. It says instead, Lacrosse and Roselle surrounded plaintiff. Okay, that's good. Plaintiff noticed Lacrosse standing in an intimidating manner with his hand near his gun. Yeah, that's relevant. Okay, plaintiff was standing calm in a non-threatening manner. That's relevant. That let them know that they didn't have no reason for standing in an intimidated manner with his hand on his gun. Do you see what I'm saying, man? You see what I'm saying?
Right. I hear you.
Okay, Lacrosse. Let me see.
I'm taking mental note.
Yeah. Lacrosse and Rosales appeared to be angry with plaintiff regarding plaintiff needing assistance in retrieving his child. That I would say that's kind of relevant. They're angry. I'm not sure what they're angry for or whatever. Then Lacrosse stated that plaintiff was under arrest. Plaintiff in shock asked LaRough why he was under arrest. Lacrosse did not answer and was arrested by. Plaintiff was arrested by Lacrosse for no reason. Plaintiff was intensely grabbed in a rude, aggressive manner by his arm, and both arms were forced behind his back and placed in handcuffs. Plaintiff was unable to leave at his will and was detained by Lacrosse. Okay, plaintiff placed handcuffs. You see Lacrosse placed handcuffs very tightly around plaintiff's left and wrist. You see left and right wrist, which caused plaintiff's wrist pain and soreness. Okay, that's kind of relevant. It depends on what kind of injuries that you would sustain, because they might say that that's diminished or something like that. What's good, beneficiary? Let me see how much more time we got. Okay, we have about 9 minutes. So let me see if I can go through this a little bit more for you. Where are we at? Damn, I lost the damn complaint. Where is it? Page 2. I lost the damn. How did I lose? Oh, there it is, right there. Let's see. When you said plaintiff was unable to leave at his free will, that's letting you know that you're being detained. You know, a reasonable person would believe, since he's not able to leave at his own free will, that he's being detained. You know, plaintiff stated to LaCrosse and said the handcuffs were too tight around his wrist. Okay. You said he did not adjust the wrist. Let's say like you have to receive some type of serious injury as a result of these handcuffs being so tight around your wrist, because they're gonna say they're gonna say, okay, yeah, you got some type of pain, but it's not that serious to the point to where you sustained like a broken wrist or blood clots in your hand or some shit like that. Do you see what I'm saying?
Right, I see what you're saying. So my follow-up question to that is that something that is found in discovery, or that's something that they take right when you file your complaint and say, no, that didn't happen. You know, well,
they go
to that.
All of your injuries, such as your rights being violated and your facts, like if you stated facts in support of each cause of action, then they're going to be asking you questions relevant to those facts and trying to disprove those facts or to mitigate the amount of damages that they have to award you if you have stated valid causes of actions. That's what they're going to do. Like, for example, when you say plaintiff, let me see, it says, as a result, plaintiff now suffers from lasting pain and numbness in his wrist expected to, you know, for the rest of his life. Let's say you get into a deposition and a plaintiff says, did you, I mean, not a plaintiff, but their attorney asks you, let's review number 59 in your complaint. When it says, you now suffer from lasting pain and numbness in your wrist. Do you remember that? And you say, you know, yeah, I remember that. You're in here, you're under oath and shit. You got a camera in your face and all this. And they say, can you explain, like, what do you mean by that? Like, did you go to a doctor? Did you go to a hospital? How did you come up with that conclusion? You know, are you feeling pain right now? Are you feeling numbness right now? You see what I'm saying? They're going to ask you questions like that.
Right. Okay.
They're going to do it on camera in front of a microphone, and you're going to be under oath.
Okay.
Got about 6 more minutes. Let me see. Plaintiff disregarded the false action. Let me see. Plaintiff disagreed with their actions and conduct against him, but plaintiff did not resist because fear of retaliatory charges, says the full death. All plaintiff asked Cross to provide documentation for the arrest. LaCrosse did not present any documentation for the arrest. LaCrosse verbally stated that he did not have a copy of a warrant in a police computer system and conducted within Milwaukee Force. Let me see. I think you might have messed up right there. It needs to be redrafted. Plaintiff informed LaCrosse and Marcells that it is unconstitutional. Let me see. It is unconstitutional to arrest a citizen without probable cause or without an arrest warrant from a judge. Yeah, that's unlawful. LaCrosse and Marcells did not acknowledge plaintiff's request and proceeded to arrest plaintiff. Plaintiff disagreed. Let me see. Plaintiff did not resist. Okay. Some of this stuff is repetitive. Like it's you're saying it more than one time. It definitely needs to be amended. If it's really up to you.
So you saying amended and keep it all at the end. Don't need to repeat that.
No, you need
everything would be
the complaint needs to be redrafted. It needs to be retyped, is what I'm saying. So you would need to, because this is the operative pleading. This is it as of right now. This is the pleading that is pending before the court right now. So what you would need to do is you would need to get leave of court, or you would need to talk to their attorney to see if she or he will be okay with you amending this petition. Amending this complaint. And if not, then you would follow, I think it's a rule 15-2A or something like that, of the Federal Rules of Civil Procedure, to motion for leave of court to amend your complaint. That's what you would need to do. Now, I mean, I do this type of stuff, man. So if you want me to do it, you can pay me to do it, or you can schedule another consultation, you know, and learn like that. But I mean, honestly, this is the only way that you're gonna learn, though. You have to fail, you know, because you have to know what you did wrong. And once you know what you did wrong, you're not gonna do it again. You know what I'm saying? So don't feel bad. Don't feel bad at all. But I can, like, man, if I drafted this complaint, if I drafted this complaint for you, this shit probably wouldn't be 7 pages. It probably wouldn't be 7 pages long, man. My complaint was probably about 4 or 5 pages. My complaint was, and that was it. That was it. The whole entire complaint. I was short, straight to the point.
Hey, I have a question for you.
Go ahead. We got about 4 minutes. Go ahead.
Have you ever filed a complaint with motel claims in there? Is that a hard thing to do?
You're talking about it suing against the city. It's a little bit more difficult to kind of sue the city. You can do it, but it's a little bit more difficult to do it. But you can do it.
Right.
Oh, because they are persons. They are considered a person, just to let you know. The state is not considered a person before
right.
You know, but the city is.
Mm-hmm. Okay.
But look, listen, man, don't feel bad. I'm gonna keep saying this. Don't feel bad, bro. Don't feel bad at all. No, you just made it.
No, I definitely don't. I take experts. I know you've done that. So that's you for me as far as the prices. I'm taking it to the head. I'm not feeling bad or negative. I like you know, positive feedback.
Yeah.
You know, and negative, whether it's criticism, whatever.
Yeah.
So that's helpful. That's why I'm calling in.
Gotcha.
I'm like, let me call brother.
Gotcha.
So yeah, man, let's sit down. Let's schedule something. And go from there. I don't know what your schedule is like this week. We need to get some.
The best way to do it is just, I guess, shoot a PayPal or Cash App or whatever. And then I'll get your number and I'll contact you, and then we'll schedule the call from there. That's how I normally do it. What time zone? You in Eastern time zone, right? Yeah, you in.
I'm in the same. I think I'm
Central. Okay, so we're in the same time zone then. I don't know. You sure you're in Central time zone? Damn, I thought that was Eastern.
Yeah,
I thought that was Eastern time zone.
Yeah.
Oh, you in Wisconsin? I thought you in Pennsylvania. Damn, I'm tripping. Shit.
No.
Okay, gotcha.
Yeah.
Okay.
Yeah.
All right, well, I got about 1 minute left on there, so I'm gonna go ahead and end this call. Unless if you had another question you want to ask right quick.
No, what I'll do, so you want me to
90 seconds.
Or just send you a PayPal or what?
It really doesn't matter, man. Whatever you're comfortable with. PayPal is, you know, your purchase is insured. So I like for people to just do that, so they just feel better about it, you know.
Okay.
But
I'll do that and go.
Okay.
All right, appreciate it, man.
No problem.
Come on.
Peace.
60 seconds.
60 seconds left. Okay, I got about 60 seconds left. Yeah. All right, let me get back to the chat because I'm not gonna be able to get nobody else. Let me see. She turned phone off, listening now, phone on hold, out of time again because it's me trying. Oh, damn. So that must be you, Libra Justice, on hold. I'm sorry about that. I didn't know that. Yeah, it's going to hang up in probably about 30 seconds, y'all. Yeah. I'm going to go ahead and disconnect not the live, but the phone lines because I only have 20 seconds left. So I'm going to end that.
Thank you for using Blog Talk Radio. Goodbye. 10 seconds.
Yeah, it's got 10 seconds left. See that? Let's get back to the group. Let's see. Okay, I'm about to go ahead and get off unless y'all have any more questions for me. Do y'all have anything that y'all want to know? If you haven't already, go ahead and hit that like button. I really appreciate that. I'm gonna go ahead and get off. Man, look, JR, this is for you. You got a real good case, man. And based on our conversation on the phone we had a while back, this is an open and shut case. Like it's just open and shut. If you draft that complaint right, if you get to a point to where you just frustrated with it, you don't think you're doing it right, I would strongly advise you to let me do it before the court just dismisses it because they just tired of you, possibly amending the complaint. I'm not sure. I'm not saying that that's what's going to happen, but it is a possibility that it may happen. But like you just stated, they let somebody amend their complaint 6 times. His phone on. I'm gonna have to call him back later. Well, I'm gonna go ahead. What was that? All right, I'm gonna go ahead and end this live, y'all, and that will be it. I hope everybody enjoys their day. I'll try to go live again sometime when I can. Also, y'all give me probably about another month or two because I'm tired of this phone. I'm gonna get me another computer, and I'll be going live from my $800 camera because it just makes no sense. I have an $800 camera and I can't use it because my computers are not strong enough. Okay, all right, JR, I appreciate it, man. If you also, JR, if you need a copy of a motion for leave of court, like if you want to know how it look, I have one on my computer. Like I said, I typed one up for somebody, I think a couple days ago. So I have one on my computer that I can, I'll give you and let you just copy it. You can draft it up yourself or whatever. Or if you want me to do it, I'll do it for you. You just let me know. It's no problem. The copy is free. I'm not gonna charge you for that shit, man. Like the copy, like if you just want me to send you an email of the copy, I'm not gonna charge you for that shit, man. But if you want me to do it, of course I'm gonna charge you for it. But if you want to do it yourself, just look at it yourself, get the format down. I would rather you do it yourself, man. That's the only way your ass is gonna learn. I'd rather you do it yourself. But if not, and you want me to do it, just let me know. So you just send it to me, okay. All right, I'm gonna send it to you, JR. Let me see. You said let me see. You're gonna email me tomorrow. All right, that'll be it, y'all. Everybody enjoy their day. The Supreme Litigant is out. Peace.